Welcome to Tutorial Sameko. Today we are discussing legal systems. So, laws within nations normally regulate relationships between entities and that nation or state. In some nations that are federal, like the United States, Nigeria, etc., where individual states within the country are autonomous, they will also have laws regulating citizens or inhabitants of those states and the state itself. And then international law will relate or reflect the relationship between one state and the other. So a state like the US interacting with the UK or Switzerland or Ghana, that is international law. Now, how the laws take shape in those countries are the responsibilities of those states. So they will define what constitutes what and how those laws come about. So a law that is defined in one way can differ when you go to another state. There are three main types of laws that operate globally. We have the common law, the civil law, and the Sharia law. We'll first look at the common and the civil law, and then we'll look at the Sharia later. So the common is a form of criminal law. The form of a criminal law is a public one, which means that it takes the state to regulate the actions of its inhabitants. So it prescribes certain actions that it expects its citizens to abide by. In terms of the civil law, it deals with relationship between individuals. So individuals can be a human being or an institution. Registered institutions are legal entities in the eyes of the law. Objective of the purpose of a criminal law is to try and whip individuals in line with the prescribed laws. For the civil, it is supposed to ensure harmony between individuals. Where a dispute arises, it will settle it and then bring out appropriate remedies for the aggrieved. Now, in criminal law, because it is a public law, it is the state that will bring the case up to the courts for adjudication. Okay, so normally the title will be the state versus the name of the offender. So the country Ghana v. Johnson. In federal states like Nigeria, it can be the state of Abuja against Johnson, or in the US it can be the state of New Jersey against Johnson. That is a criminal law. So in cases where the state or the country does not deem an action to be in contravention of their law, then that criminal law will not come in, or that persecution will not come in. In civil cases, it must be brought about by an individual who feels aggrieved. So the title will be the names of the parties involved. So Joel versus Martin. Now, in criminal law, the parties are known as the prosecutor and the accused. So the prosecutor is normally an official of the state who will bring up a case against somebody who flouts the law. Now, the person who is alleged to have flouted the laid down rules and procedure is the accused. Now, in civil, the parties are known as the claimant and the defendant. So the claimant is the person who feels aggrieved by the actions of another individual. That is the defendant. In criminal law, the onus lies on the prosecutor to prove that the accused really contravened the laws of the state. They must bring evidence to state that indeed the person that they are prosecuting really has flouted the laid down laws and procedure of the state. In case of the civil law, the claimant is responsible it is not the duty of the defendant to prove so. In the criminal law, the standard for which an accused will be ruled as guilty of those charges is very high. So the prosecutor must prove without any loophole that the accused is guilty. With a civil, it is the standard of probability. So when there is a likely claim that the claimant is offended, then the case can be ruled in the favor of the claimant. So the level of standard of proof for the civil is much lower than that in the criminal law. Basically because the punishment or the consequences in both cases, the criminal law far outweighs that of the civil. Now, the objective of the criminal law is to punish those who flout the law. For civil, it is just supposed to compensate the aggrieved person who is the claimant. And normally it's a financial compensation. And it's normally supposed to restore the aggrieved party to the position had the action of the defendant not executed. Now, the outcome of a criminal law is to imprison the accused if found guilty or made to pay a fine. Now, in civil law, when the defendant is liable, he will be made to pay damages. The person will hardly be imprisoned. Now, the payment that is known in the civil law is supposed to restore the claimant. So the fine in the criminal law is supposed to cause the accused to feel the pinch of his action, sort of to punish them. Now we come to the Sharia law. These are laws that are found in regions that are heavily dependent on the Islamic religion. So the laws are deemed to have been offered by their supreme being, in this case Allah, and it's deemed to be in the benefit of mankind, people who subscribe to the Islamic religion for their betterment. Now the sources of Sharia law is the Quran, their holy book that contains Allah's revelation to its subjects through the Prophet Muhammad. The second one is the Sunnah, which is a record of what has come to be acceptable course of conduct expected of the people who subscribe to the religion. And it is also derived from the sayings of the Holy Prophets. So the sayings of the Holy Prophet is normally termed as ahadith. Then you have the madhab. These are schools of thoughts of major historical jurists. Okay, and their writings, which has become a standard for the application of the Sharia law. Then you have the constitution. So in countries that are solely Islamic, like the Saudi Arabia, their highest making body will propound laws which is supposed to be applied in the Sharia law. We'll come to the role of judges in Sharia law. So mainly, the judges in the Sharia law are clerics because of the religious nature of the law. But in some cases, the judges might be secular. They might not necessarily be teachers in the faith, but they must be subscribers to the religion. They are also expected to apply the law of the Sharia to the letter. Now, the extent to which they have leverage or they have discretion to apply it is limited. Everything must be subscribed to the holy book and the inspirations of the supreme being.